can catch it there. All right, and then of course we got our Facebook page. We might put a few snippets of this video on there, but check it out. There's always some good, interesting information there related to real estate. Now, without further ado, I want to go ahead and bring out Andy Mirza for Coastline Capital Fund. He's going to be talking about the 5 exit strategies for non-performing notes. Andy, you out there?
I am, Omar. Thank you very much for having me. I'm pretty excited to be here. It's always great to talk to a bunch of investors about what I'm doing and share that kind of stuff. I'm going to go ahead and start this PowerPoint that I have here. And let's see. Let me know if you guys are seeing it. Oops. I think I was supposed to share the screen first.
Oh yeah. Do the screen.
Okay, I'm sharing my screen, and then there we go. Can you see just the slide that says 5 exit strategies and nothing else?
Yep, we're in business.
Okay, perfect. I'll get started then here. So this is, I'll be explaining my 5 main exit strategies for non-performing notes. If you don't know what a non-performing note is, that's okay. I'll talk a little bit about it in a few minutes here. But mainly this presentation is for note investors and people that know something about notes. If you already are investing in notes, you'll find a lot of information helpful because I'm going to go into a lot of detail on these different strategies. I'm also going to provide case studies with some real numbers. If you just want to learn more about notes, this is also going to be a good talk for you. And, you know, if you don't end up investing in notes, this information will help you as well if you're involved in any kind of real estate, because I will talk about REOs and basically real estate from a creditor or a lender's perspective. So it'll be helpful in those kind of ways. So let's talk about the agenda that I have for tonight.
Hey, Andy.
Yes.
Let me just chime in real quick for anybody that came in late here. If you have any questions for Andy, make sure you type them into the chat box. And myself and our assistant Zaldi, we're going to monitor the chat box. And when there's a good pause and it's appropriate, we'll go ahead and let Andy answer your questions. So, thank you, Andy.
Awesome. Sounds great. So the first thing, I'll talk a little bit about myself and my background with notes. This is basically a continuation from the last talk I did. I presented in July of last year about buying notes from hedge funds. So if some of this stuff it seems a little bit over your head, you can access that and take a listen to that. And that's more of the introduction. And this is more of a continuation. So that talk last year was about buying the notes and acquiring them. This talk is going to be, well, once you get those notes, what do you do with them? The 5 exit strategies, I'm going to go ahead and tell you them right up here, right up front. The first one is selling a property at auction at the foreclosure sale. This is pretty much what everybody thinks of when they think of foreclosure sales. It's the auction at the courtroom steps or the courthouse steps. The second strategy is selling the property after the foreclosure sale as the REO. So if you're the winning bidder or winning credit bidder as the lender at the foreclosure sale, the property will revert back to you and you sell the property. The third strategy is negotiating a deed in lieu of foreclosure and a cash for keys agreement with the borrower. That's pretty much for borrowers who just want out of their situation. You can set up a situation where they basically deed back the property, give you the keys, and you give them some cash, and they're done with the deal. The next one is a short sale or short payoff, and this is one where if the borrower is underwater and owes more than what the property's worth, and you acquire it for a lot less than what the payoff amount is, you're in a position where you can allow that borrower to do a short payoff or a short sale. And then the last strategy is reselling the loan. And actually, I've included a sixth strategy, and we'll get to that one at the very end. But these are the 5 exit strategies that I focus on. That sixth one is kind of a bonus, and that's for note investors who, I'll explain a little bit more about how it ties into for other note investors. I'll give case studies of each of these different exit strategies along the way. So I'll give the story of the note from beginning to end, so that we're not just talking about concepts. Concepts stick a lot better, in my opinion, in my experience, when there's a good story attached to it. And then following, we'll have a Q&A session. Again, as Omar stated before, if you just go ahead and put your question in the chat box, Omar will go ahead and monitor that, and he'll interrupt me at an appropriate time, and maybe we can answer some of these questions along the way. That way you don't have to wait all the way to the end if you have a question on the next slide. Okay, so that's me, a better picture of me in a suit if I have to wear one, which is not very often. I get to work from home. Pretty much the only time I might put on a coat is if I go to a convention and network with others. I'm the Chief Operating Officer of Coastline Capital Fund Management. Since 2015, we purchased $11.5 million worth of notes. To date, we've liquidated $7.5 million, resulting in $1.5 million in net proceeds. The average weighted return on the investment per note was 33%, and the average weighted annualized ROI per loan was 55.6%. And we kind of got hit a little bit by COVID. We had a lot of foreclosure moratoria and eviction moratoria that slowed us down for our last few funds, but we're actually benefiting on our recent funds because we have a lot more notes that are in late stage foreclosure, so it's allowing us to liquidate faster. So what we do, so Coastline Capital Fund Management, we create and manage funds that invest in defaulted mortgages. We buy first position non-performing notes backed by residential real estate. So for the people that don't know what a non-performing note is, it's a loan, and the loan is secured. The interest in the note is secured by real estate through a mortgage or a deed of trust. And defaulted mortgages means when somebody has a loan and they stop paying on the loan. So after they've been in default for 120 days, you're allowed to start foreclosure. These non-performing loans that we buy, most of them are toxic home loans left over from the financial crisis of 2008. We actually do still see tapes of notes where the paid to date or the last date that the borrower made a payment was before 2008, but it's more rare these days. What we see a lot are people that have had loan modifications, 1 or 2 of them. We see people that have filed bankruptcies. We see people that were able to reperform on their home loan for a while, but then they just weren't able to do it. So those are the kind of situations that we're encountering. Our basic strategy is we buy low and liquidate high. So we buy the note at a discount at a low price, and then we liquidate at a higher price. And that's what we'll discuss with these 5 exit strategies. We prefer the severely delinquent loans because they have the highest returns. Think of us as fix and flip guys for notes. Basically, the fix and flip guys, if you have a property that has burned down and you have to take it down to the studs, you can expect to get the highest returns. The more problems that the property has, the more there's a potential for profit. So same thing with the notes. The more delinquent it is, the more problematic it is, the more title issues there are to it, the more value you can potentially bring to it. So that's our business model.
Andy, can I chime in real quick with
Sure.
that's very interesting that you're still seeing non-performing notes that were originated back in the Great Recession. Are you seeing? I know you said you weren't. It's not as often nowadays, but were those loans that had not been receiving payments for like, many years, like 5 years plus? Is that what you were seeing, or was that?
Oh yeah, I've been looking at a tape of notes just today where some of the paid to dates. So a paid to date means the last day that the borrower made a payment on the loan, right? So I have paid to dates from 2008, 2007. We bought the oldest loan that we bought was where a paid to date from 2005.
So did that mean that was the last date they received the payment on it?
Well, yes and no. I mean, it's easier to think of it in those terms, and sometimes it's true. But say someone stopped paying on their loan in 2010. Well, if they made a payment on the loan in 2015, like one or two, they apply those payments from 2015 back to 2010. So say they stopped on January of 2010 and they made two payments in 2015, they'll show that they paid for the February payment and the March payment for 2010. So it'll look like 2010 was the last time they paid, when they might have paid, a lot later than that. But I think as a general rule, what you're seeing with that paid to date is the last time the payment came in.
Oh, wow, that's interesting. Okay, yeah, thank you for that.
Yeah. Okay, so institutional loans, they are hard assets. Loans are personal property, not real estate. It's a very important distinction. Sometimes a lot of times people come from a real estate background and they want to venture over into notes. And that's one of the hardest things for them to wrap their minds around, is that notes are finance, and there are a lot of rules and regulations and strategies that you have to think about differently. You can't just say, oh, I'm going to buy this non-performing note and then I'll be able to foreclose and flip this house. And you got to look at strategies a lot more carefully, because it could get you in trouble. So banks, hedge funds, investors, they buy and sell loans just like real estate investors buy and sell properties. So that's another thing. Like the layman out there doesn't think of loans the same way as they think about real estate, but loans are bought and sold all the time. It's just like any other asset. When banks get in trouble, they sell some or all of their non-performing notes to other banks or hedge funds. Typically, you'll see the biggest pools of notes get sold to the biggest banks, and they in turn will keep what they want. They'll sell the rest off to smaller hedge funds. Those smaller hedge funds will do the same thing on down the line until it gets to the bottom street level investors, or the people that are going to take it all the way to liquidation. Okay, and this is another important thing to really understand if you're new to notes. What the borrower owes the lender is fixed by the note agreement and can be completely different than what the current note holder bought the loan for, right? So the face amount of the loan might be $100,000. Maybe they went into default and stopped paying, and now they actually owe $150,000 on that note. That borrower owes $150,000. Now, you as the owner of the note, you can say, well, I don't want to wait and go through this whole process of collecting to get to my $150,000. I would rather take $80,000 for it today. And then they find another note investor on the secondary note market who will buy that loan for $80,000. The seller of that note, is free of their asset, and they have the cash, but the borrower still owes the 150. What you paid for that loan is completely irrelevant. It doesn't matter. So that's another important thing to get in your head. It's very similar to real estate as well, right? What you buy your real estate for doesn't really matter to the person you sell it to. The price is what the price is. So as a note investor, determining which of these 5 exit strategies you should pursue, you really need to look at what your end goal is and your business plan. Like I was explaining before, our business model is more of we're looking for the severely delinquent loans because they have the highest return. And we're looking to find some resolution for these loans pretty quickly. And that has a lot to do with our fund structure, because we raise capital from accredited investors. We promise, or we target a certain return for those investors. And our business model is that we're going to return money as quickly as possible. So we don't have a long-term hold strategy. This is kind of equivalent to fix and flip investors, versus rental investors, right? Like if you're doing fix and flips, you don't really want to hold the property longer than you have to. You have a lot of carrying costs and you have a lot of expenses, and you want to get to that big chunk of change, right? So that's kind of like, are you looking for, what is your goal? So we're looking for the large chunks of money. That's our main business goal. If you're a rental real estate investor, you're not as concerned about the large chunks of money. You're looking more for the stable monthly income. Do you want to be active or more of a passive investor? If you want to be more of a passive investor, you're probably going to be involved in more performing notes. If you want to be more of an active one, like myself, then you want to have these delinquent non-performing notes. But then also in my category, there are different levels of note investors out there. My business partner, he owns an asset management company that liquidates REOs for other hedge funds, including ourselves. So we're not afraid to get our hands dirty with an REO. But there are some note investors that you're based in California, and you might have something that a note that forecloses in Virginia or Florida or Texas or somewhere like that, and you are not set up or equipped to deal with REOs. As a matter of fact, it would be a huge inconvenience for you to have one. So you would have a lot bigger motivation to pursue certain strategies so that you avoid the REOs. So that point right there is, are you willing to take the REO on from a distance or at all? So some investors don't want anything to do with it. Some people get into notes because they want to get away from tenants, toilets, and trash. They don't want to deal with that stuff anymore. And maybe they don't want to deal with the REOs or what's involved with fixing and flipping a property from far away.
Hey, Andy, can I chime in with the question on that?
Of course.
Point here?
Go ahead.
So you were saying, say if a note investor, their note turns from performing to non-performing, do you typically see that, if they're, like you said, a passive investor, they're going to want to sell that note at a discount instead of going through all the rigmarole of foreclosing and REO? Or,
Maybe we have one seller, one hedge fund, and their business model is to make just a little tiny bit on all the notes that they buy, and they'd rather just flip all the notes. So if they get a note and they can sell it in 1 or 2 months and maybe make $5,000 off it, or 10 grand, or some other metric that qualifies for them, they're going to do it. And then that leaves a lot of meat on the bone for the next guy, but that's just their particular business model. They would rather not have REOs. If you think about it, some of these Wall Street hedge funds, you're talking about people that couldn't be any farther from a street level investor, right? You're talking about maybe these are generalizations, but they're actually true. Like some are people that just graduated from Ivy League colleges and went straight to New York and are working for a fund out in New York. They have no idea what an REO is really about. That's why you have a lot of decision makers. Like if you're a real estate investor and you have experience with short sales or REOs, you can be incredibly frustrated by the stupid decisions that some of these banks make. And one of the reasons why is because there's such a big disconnect between the people that are making the decisions and what's going on and at that location. Does that answer your question?
Yeah, no, that's very interesting. Thank you for that.
Okay. So here, I'm going to spend a little bit of time on this first exit strategy because I think it's important to lay a foundation. And it's kind of like one of the things where you kind of start with a foreclosure if you can't work something out with the borrower. So first exit strategy, sell the property at foreclosure sale. So we're talking about, for this one specifically, once you've started the foreclosure, there's a foreclosure sale. And once that foreclosure sale takes place, if there's a third party bidder that wins at the auction at the foreclosure sale, they get the property for that amount. And then that amount, you get the net proceeds of that amount, which is what satisfies the loan. And then you're out of it. You're out of it at that point. So for this strategy to work, basically you are looking at what you bought the loan for, and then what the third party bidder will win it at foreclosure sale. And then that's your profit, the difference between that. So these are auctions that, like I was saying before, well, here I'm saying that it can be online or in person. So online has been in advance over the last 10 years. More and more sales are happening online. But really, like when people talk about buying properties at the courthouse steps, this is what I'm talking about. So if they're in person, they can be run by a sheriff, a constable, an agent of the trustee, or other court or statute approved selling agent. That also includes online. So in Florida, they have some foreclosure sales that are strictly online. Here in California, we're a non-judicial state. So the auctioneer is someone that's hired by the trustee to conduct the sale. And let me go back a little bit further. So this is just the exit, but what am I talking about on a foreclosure? Like, how do you initiate a foreclosure? So there's also a parallel, like, so basically you contact an attorney or a trustee company that specializes in how to do a foreclosure. And those people will file the paperwork and get the ball rolling on getting that done. You can do it yourself, but you can also do things like evictions yourself, right? Most people don't do an eviction themselves, at least someone who's doesn't have the time to deal with that kind of thing. But the first step in the foreclosure process, and I'll do this by, since we're in California, I'll talk about non-judicial, but here in California, the first step in the process is that you file a notice of default, and that's a recorded document. Again, like I said, you can actually do this yourself, but you can also do evictions yourself. But I think most investors, at a certain point, they're not going to do their own. They're going to hire someone who specializes in it, like an eviction attorney. Same thing for doing the foreclosure. Here, you can use an attorney or you can use trustee companies. The way it works in California as a non-judicial state is that when a borrower executes a deed of trust and you have that recorded, if they go into default, you as a lender, you don't directly foreclose on them. The law is that you have to have a trustee, which is a designated third party that agrees to follow the statutes and the laws on how to conduct it properly. So it's trying to avoid the whole predatory lender thing. If you have a direct lender and borrower interacting with each other, then there are no protections for the borrower to protect from predatory lending activities. So that's why a trustee is set there in place. And they actually conduct the foreclosure on your behalf. And when it's concluded, you're the beneficiary of that deed of trust. And so the trustee is that third party to do it. So it starts out with a notice of default. In California, there are 90 days for the borrower to redeem. In that time, there are a lot of different notices that go out. These are required for compliance reasons. I don't know exactly all of them, but it seems like every year there are more and more of these requirements. Again, that's why we use a third party to pursue the foreclosure, because if you mess up any of the steps involved, then you can put your foreclosure in jeopardy. Just like when you're evicting a tenant, if you don't do it in the right way, if you don't serve them properly, if you don't do any of the steps necessary to pursue that eviction, if you don't do it properly, you're gonna have to start over again. So after 90 days, your trustee will file what's called a notice of sale. And after that, the sale can happen 3 to 4 weeks later. So that's the process in non-judicial state. If you're in a judicial state, it's a little bit different. So in a non-judicial state, it's almost like it's a lot quicker and it's a lot smoother. And it's the biggest reason why there's not a huge backlog of foreclosures in those states. It's almost, it's pretty much, if you follow the right process, the foreclosure goes through. It's only if there's like something really materially wrong with it, where a borrower says, hey, you're foreclosing on the wrong house. And then they file a lawsuit and stop the sale. In a judicial foreclosure state, everything goes through the courts. So you have to file a lawsuit against the borrower saying that they defaulted on your loan. So you go through the same process that you might with an eviction proceeding. You file a complaint with the court. Again, you could do this yourself, or you could hire an attorney that specializes in doing this, and it goes a lot quicker. The borrower needs to get served. Once they get served, they have a certain amount of time to reply or respond. If they contest the foreclosure, that opens up discovery and a whole bunch of other stuff. But for the most part, most borrowers aren't fighting the foreclosure complaint. The next step in the process is that you get judgment from the court. The judge basically looks at all the documents, make sure everything's in order, and then he'll issue an order of foreclosure. At that point, there might be a redemption period, or you just go straight to scheduling a sale. And that's where it's a lot more common in judicial foreclosure states, where you have that sheriff's sale, or you have a constable sale, or you might have some other form of judicial sale. And then once the property goes to the auction or the sale, unlike California, where once that auction happens, you sign over the checks because you want it, you get the deed 10 days later and you're done. Judicial foreclosure states operate differently. Once you actually have the sale, you have to get a confirmation of that sale. So you have to have a hearing. Usually it's about a month later. The judge says, okay, I see that you've done everything properly. And then he issues the order to confirm the sale. And then after that, you might wait another couple of weeks or a couple of months to get the deed. And finally you're done. So kind of a big difference in how this happens.
Andy,
So,
we got a question in.
sure.
So Hamid is asking here, how much does a foreclosure generally cost?
Okay, in the costs will run lower in non-judicial foreclosure states. So generally, it's going to be about $2,000 to $5,000. Now, if you're in a judicial foreclosure state, that's going to run more in the $5,000 to $10,000 range. It's going to run higher if the borrower / defendant litigates and fights. So it can be higher than that 10,000.
Okay, thank you.
You're welcome. So here, let's talk a little bit about strategy. So I explained kind of the process so you can kind of understand what's going on. Right, I need to click on here and it's not moving for me. There we go. All right. So you need to set your opening bid or maximum credit bid. So in California, say the total debt on a property is 200,000. Say the property is worth 100,000. You get to set the opening bid. You get to set the opening bid for anything up to the amount owed, right? So you can do it at 200,000, but if the property is worth only 100,000, you're pretty much guaranteeing that you're going to get it back as REO, because nobody is going to bid $200,000 for a $100,000 property. Now, if you want to take it back as an REO and don't want to mess around or waste time, then that's what you do. You set it at 200,000, you know you're going to get it back as an REO. If on the other hand, you're like, I don't want to take this property back. So then you got to figure out, well, where do I want to set this opening bid? If you set it at 50,000, you're pretty much guaranteed that you're not going to get the property back. The bidders at the auction are going to start at 50,000, and then they're going to start bidding it up until there's only one bidder standing. And I don't know what the going rate is for properties at trustee sales nowadays, but maybe it's 70,000, 75, 80,000. Maybe it's higher than that. I mean, the real estate market's been crazy. So I wouldn't even be surprised if it went for 85 or 90,000, right? So it kind of depends on what your goals are. Do you want it back? Do you not want it back? So back in the day, so 2011 to 2013, I was buying condos at trustee sales. And so I have experience as a buyer. And one of the things I noticed is that whenever you saw a lowered opening bid, that usually indicated that the lender was ready to sell the property. If you saw that there was no lowered opening bid and it was just the judgment amount or the total debt amount. So say, for instance, a lot of lenders and big banks would on my example, would just have it at the 200,000. Or, usually it would be like $205,612. Some uneven, weird amount, right? But then if I saw that the opening bid was a flat number, like 50,000, that indicated to me that they're taking steps that they want to sell the property. So it's more likely to go to sale, right? And the earlier that opening bid is published, the more exposure you're giving potential trustee sale buyers, right? So back in the day, you had a lot of networks and a lot of teams that were very active, and you had all these people that were ready and able to buy on a moment's notice when they lowered the opening bid on the day of the sale. I mean, really, just as the sale happened, all of a sudden you get this lowered opening bid. Well, that cuts out all the smaller buyers, right? Because I'm not gonna spend all my time going to every single sale. But if I see that a sale has a lowered opening bid, I'm gonna show up. So setting your opening bid a week before the sale gives you exposure to a lot more buyers. Now, for us, we try and find a sweet spot. We try and set, so I don't want to set the opening bid to 50,000 because there's a chance in my example that there's only one person that shows up to that sale for some reason. And I wouldn't be okay with that property selling for $50,001, right? So for me, we try and set our opening bid to something that's more than what most fix and flip investors will pay, but maybe you might get one or two that are willing to take it on. But it's also a bid that would be acceptable to a buy and hold investor, or maybe actually a consumer that wants to get a deal, wants to get a home that they're going to live in and they don't mind fixing it up. So that's where I like to set the bid. So in my example, we would probably set it at like 70 or 75. And then, hey, if it sells, it sells. If it doesn't, it doesn't. We'll take it back as REO. Hidden credit bid. So I never liked this when I was a trustee sale buyer. So a hidden credit bid basically means this: you can set the opening bid at 50,000, but secretly you're going to have the auctioneer bid on your behalf to a different number. So that different number in this example might be 80,000, but you're actually holding and conducting an auction starting at 50, but the bidders don't know that the real opening bid is 80,000. So I never liked that. So I pretty much never do that, but there are exceptions, which I've had to do recently. And if we have time, I can get into that story, but I don't want to get too deep into the weeds on any of these things. I want to keep us moving. So keep in mind, and this is also another point of the mind shift from real estate to notes. So you are entitled to collect up to the amount of the total debt owed on the note obligation, nothing more. So let's flip it around. So the property is worth 200,000, but the total debt owed is 100,000. See, this is where maybe a real estate investor might think, oh man, I can buy this note in default for $100,000 and get a $200,000 house. No, absolutely not. It doesn't work that way. If you have that foreclosure auction, the bidding is going to go much higher than 100,000. Say it goes to 150. What's going to happen is that you get from those proceeds of that sale at the auction, you'll get your 100,000 that you owed. But then the 50,000, and I mean, I got ahead of myself. That 50,000 is excess proceeds, right? So the excess proceeds are going to go to any junior lien holders in order. If there's a second mortgage on the place, that person will get paid up to, either if there's a second mortgage of $50,000, they get the whole 50,000. If the second mortgage is 75,000, in that example, they would get 50,000 and no more. But say, for example, there was a second mortgage for 20,000 and a third mortgage for 30,000. Well, that third mortgage will get paid, right? If there are no junior lien holders, the excess proceeds will go to the property owner. All right. Any questions at this point, Omar?
No questions, but I do want to come back to an earlier question. Kelly was asking where to find the video of Andy's previous talk. Yeah, last time you spoke, which was a year ago. Yeah, well, like I mentioned in the beginning, that's going to be on a private link. So we'll have to dig that up, and maybe we can share it with you folks, but we'll have to dig it up at first. So it's probably somewhere in the library somewhere, just so you know. But yeah, that's the only other question at this time.
Okay. I will go into the first case study. So quick New Jersey sheriff sale. This is actually the title of a blog post. So I do write blog posts about individual note deals that we do, and I put it on our website. I'll put the information on where to find it at the end of this, but that was the title of this particular blog post. And all the different case studies actually have their own little titles, and I took it right from the blog post. So in this situation, this is for one of the ones that we bought for our last fund. It actually was in late stage foreclosure. That's something that we're finding with a lot of the notes that we've been purchasing, kind of after everything's been happening with COVID. Basically, a lot of things were shut down. Some states didn't shut down so much, and a lot of foreclosures were able to progress in their liquidations and kind of got hung up right at the end, where everything was done to the foreclosure except they wouldn't let them go to sale. So you have a lot of these situations where it's at the last step, right? So this was kind of one of those situations. We were fortunate because the seller of this loan, they were pursuing a business model where they were contacting the borrowers and trying to offer them cash for keys prior to the loan purchase. That way they would be left with a vacant house when it was time to foreclose. And a vacant house is easier to sell if you don't have to deal with any of the occupants with it. So in this case, actually, I'm calling it a New Jersey sheriff sale because the sheriff is normally supposed to conduct these sales. But kind of near the end of these restrictions during the COVID era, some judges were starting to allow special entities to conduct sales because the sheriff's office is independent of the courts, right? And the court can give the order to the sheriff, hey, sheriff, sell this property. But the sheriff, they run their own department, and they can say, well, we're just not going to run any sheriff sales right now because we don't think it's the right thing to do. And sheriffs are elected, so there's some politics that comes into play. So for this particular one, our attorney said, hey, we don't know when the sheriffs are going to let the sales start happening again, so we can petition the court and have them have a special master. I don't know, that's just the terminology that they use, but we say, hey, go ahead. So we filed the motions, and we were able to conduct the special master sale. So again, I was talking a little bit about setting the right opening bid in a hot market. So we're just, in a hot market, it's easier, but again, we don't want to risk having too low of an opening bid and then get stuck with somebody who just pays $1 over it, and then we're getting a lot less than what we wanted for it. Again, we're not afraid of taking back the REO, but we want to have that bid where it's high enough that if we sell it at that opening bid, it might be better than, it will be more profitable in less time than if we actually took it back as an REO. Because at the end of the day, a local investor is always going to have an advantage over us since we're investing from afar. And there are just things that make making liquidating REOs more difficult than any skilled local investor. So I'd rather give it to the skilled local investor if I can at a good price and let them make a profit with it.
Hey, Andy, just a quick question, because I know we got some new people here. You mind educating some of the new people what REO stands for?
Yeah, so REO, sorry about that. That's a common term for real estate owned. That's a term that banks used back in the day, like when they foreclose on the note and it reverts back to them, they call it an REO.
Awesome, thank you.
So for this particular deal, here's some final numbers. So the purchase price of the note that we bought was $278,000. The total cost basis is $285,972. So the cost basis, that means the purchase price plus all the expenses minus any income we might have had, but basically all the expenses that we put towards the asset is counted in the cost basis. So it's purchase price. It's any amount that we advance for property taxes, any money that we advance for insurance. It also is the money that we paid to our loan servicer to service the note. It includes attorney's fees. It includes just anything that we have to spend on the note. That's all the money we're into it. So the third party winning bid at the sheriff's sale was $399,100. So we set the opening bid at $399,000. There was one person that bought it. And we were surprised and pretty happy with it. Not all our deals are like this, but that's one of the things about buying notes is you're going to have a lot more of a range of your returns. When you're buying real estate, when you're doing a fix and flip, you're really your numbers are a lot tighter because you're more in control of what's going on with that. When you're buying notes, there are two things that are outside of your control. You can't control what the borrower is going to do. So instead of having a 6-month turnaround time, you can have a borrower that fights you actively in court or files bankruptcy on you and extends your 6 months into 2 years or 3 years or longer. The other thing that you can't do is you can't inspect the inside of the property, so you don't know what the condition is. So you're going to have a lot wider range of potential returns. But going back to this case study, we held that for 154 days. What's that, like 5 months? So not too bad. This was earlier this year, so near the post lockdowns and that kind of thing from COVID. Return on investment came out to 33.9%. The annualized ROI was 80.2%. So that was a really, really good deal for us. So the second exit strategy is just a little continuation on what we just discussed here. So in this situation, you actually are the highest bidder. So when you set that opening bid, that's actually a credit bid. And that means that the trustee is bidding on your behalf and you're allowed to bid up until the total amount of debt. So this is a situation where on that $100,000 property, you set the opening bid to $200,000. Nobody is going to bid on that. You're going to be the highest bidder. So in California terms, they'll say it reverts to the beneficiary, which the beneficiary is the same as the lender. If you're in a judicial foreclosure state, they're gonna the term that they're gonna use is sold to the plaintiff, and the plaintiff is the same as the lender because you're the one that's initiating the lawsuit.
Hey, Andy, a question just came in. Paul is asking, I think is referring to your last example. What was the outstanding balance on the note?
Ooh, okay. So I don't know that off the top of my head. Think it was around 420,000, something like that.
Oh, wow.
It's in excess of the maximum credit bid that we set. So I said we set 399,000. So there's no way that the outstanding debt could be lower than 399 because I'm only allowed to collect what the total amount owed. So the total amount has to be higher than that. So I think from the top of my head that if the market value of the property might have been around 450, so the total debt was kind of close to it. So that's just kind of how that came out. But because we bought it at that price, we were really able to, I mean, that was a phenomenal return. Why mess around with that return? Just take the money, let the next guy have it and deal with it.
Yeah, okay, very good. Thank you for that.
Sure. So in this situation, you're the high bidder. So the property becomes yours. The debt is extinguished, and basically the property is your exit and your way to liquidate and make a profit. And I think a lot of real estate investors that transition over to notes are kind of thinking about this strategy as their main strategy. The only problem with that is, like I said, if the borrower does something that's outside of your control, you're thinking, oh, I'm going to be in and out of this in 6 months, and then they file bankruptcy, and then you're stuck for 2 years. Well, the problem comes in if you borrow the money, right? So with a typical fix and flip property, you're borrowing part of the money to buy your fix and flip. If you try and borrow the money and you owe a lot of money to an investor or a lender who happens to loan you money for that, you might be stuck with a big loan payment that you can't readily retire. So in a non-judicial foreclosure state like California, if you are the highest bidder, what happens is that the trustee goes through the procedures that they have to do. They basically receive the funds, and then they satisfy all the different liens that they need to, and take out the fees that they have to take. And then the net proceeds get sent out. Well, actually, since this is an REO, there's not going to be any net proceeds because there was no third party bidder, right? You are the winning bidder on it. So they basically just process the paperwork, and they record a deed for you, a trustee's deed upon sale, send that over to you, and then that shows that you have ownership of the property. In the judicial foreclosure state, the sale happens, you're the high bidder, you have to wait about a month for that confirmation hearing to happen. Once the judge orders the sale confirmed, that's technically when you own the property. So at that confirmation hearing, once the judge says, yeah, it's yours, I sign the order, it's yours. But practically, you really do need to wait until you get that deed, the sheriff's deed or the judicial deed, and get it recorded before you can really start. Contractors that are going to do work on your property, they're going to want to see that deed. Sometimes the cities or the towns that have local ordinances that will affect your property, they want to see that deed recorded before you do anything. So really, you need to wait till you have that deed before you can start on what you want to do. So once you get the deed, you want to work on clearing title. So you want to record that deed as soon as you can to show that you are the new owner. You need to pay the liens that stay with the property. So there are some municipal liens, like for unpaid water bills or sewer bills, certain liens that will stay no matter what happens with the foreclosure. Like foreclosure will wipe most liens off, like if you have a second mortgage or a third mortgage on the property, those guys get wiped out. And that's just how it goes. That's why they're in the riskier position of second or third mortgage. There are IRS liens. If someone owes a lot in federal taxes, generally those will drop off. The only time that they won't is when there's equity in the property. But if the property is underwater and there are no excess proceeds, those IRS liens will just drop off. Judgments, like from civil cases or basically any kind of civil judgments, they attach the person and they're on the property to basically prevent that person from selling that property. But in the foreclosure, those things get dropped off. You want a clear title because if your intent is to sell the property, you need to have clear title to sell it. So the next step in handling an REO is that you need to find a local real estate agent. That's how we do it. My partner, he has an asset management company, and that's one of the first steps in the process of taking on any REOs, is that they'll find a local real estate agent that basically is our eyes and ears and boots on the ground. They'll do everything for us. They're our proxy or our substitute for us. So that's what we need. You make contact with the occupant. Again, this is gonna, a lot's gonna depend on what your business model is. Are you gonna offer cash for keys? Are you gonna offer that occupant, hey, we'll give you X amount of dollars if you vacate in 30 or 45 days? Do you want to try and convert them to a renter? If they're already renting and they were renting from the borrower, maybe you want to keep them there as a renter. Or do you go the eviction route if they're not cooperating with you? And at this point, it's just like any other investment property. And again, it depends on what your business model is. If you take it back, do you want to sell it as is? You can do that. Like if you don't want to do the rehab from far away, you can just say, you know, I'll just sell it for what I can get for right now. Or you can go in there, put in some work, sell it for more, or you can hold it on as a rental. So here's my second case study. Omar, I'm looking a little bit at the clock, and I'm afraid that if I go into too much detail on some of these stories, that we won't have enough time.
Yeah, it's about what I got. That's about 8:20. So yeah, I agree.
Yeah, so I'll do a real brief overview on some of these stories and get through some of this stuff. I would rather have time at the very end so that we can go back and people can ask questions on stuff that they really want to have the answers to.
Yeah.
So
yeah, guys, make sure you put in your questions before Andy takes off for the night.
Yeah, so this one, this was in Las Vegas. The foreclosure was already in process. And then I was kind of surprised because we had a sale date just a couple of months after we bought this loan, and the borrower filed bankruptcy to stop the sale. I was surprised because during the due diligence period where I bought the loan, I saw that she was already in bankruptcy, but she had given up the property, or the previous lender had gotten relief to sell the property. So it kind of surprised me, but it caused me to dig in deeper and find out what was going on with the note. And this was one of those people. She had like a 4,000 square foot home. She had this was like her third or fourth home. So she had that huge home. She had another home. She had this home as a rental. She had another home, and she was kind of playing a shell game. And she was in bankruptcy on basically all the homes, and she was in danger of losing all of them because of defaults. But she was playing a game and was doing it over the course of about 7 or 8 years. But getting into that story of the note allowed us to come up with a good strategy with our attorney on how to get relief. So we were able to get that relatively quickly within a month. And then at that point, once we successfully foreclosed, we dealt with the occupants. They were uncooperative. They didn't want to have anything to do with us. And right then, COVID hit. That was about March of 2020. We had a few months delay. In retrospect, it was actually a very short delay, but at the time, when all of our liquidations basically got stopped for a couple months, we were beside ourselves trying to get things moving. So after 3 months, it was actually kind of surprising because we had the lockout order, but the sheriff wasn't doing the lockouts for any tenants. But one day he called us up. He called our agent up, or no, he called my partner up and said, "Hey, we we can do this lockout. Are you guys available later on this morning?" and we just jumped on it like, yeah, we're gonna get our agent right out there. And sure enough, that was the quickest lockout I've ever encountered. I bet these guys had a huge backlog and they were just trying to get these things done. And so within a few hours, they had done the lockout on the very morning that they called us. So as soon as we did the lockout, we did a quick rehab and then we put it on the market. So for this guy, purchase price was $190,000. Total cost basis, including the rehab, the eviction costs, everything, $227,000. Sales price, we sold this for $299,500. I bet with the real estate market the way it is right now, it's probably worth a lot more now. But that gave us a net sales price of $280,000. We profited by $53,000. We held this one for a little bit over a year, and that was more. I mean, part of it was that eviction part of it, but part of it was also the rehab and all of that. Return on investment, 23.7%. Annualized ROI, a little bit lower, 21.8%. Still a solid deal. So third exit strategy is deed in lieu of foreclosure. So this means the borrower can deed us back the property in exchange for being released from the debt obligation. So a lot of times we're dealing with borrowers that are trying to stay in their properties for as long as they can by paying the least amount possible. And so the first two exit strategies are really the primary ones that we have, right? It's kind of an involuntary thing. The borrower doesn't want us to foreclose, but that's our remedy. We get to foreclose in order to collect on the debt that's owed to us. So most of what we do are the first two strategies. This applies to those borrowers that reach out to us. In general, I mean, we'll try and reach out to our borrowers, but if they're not willing to meet us halfway, it's kind of a waste of time because they're just trying to scam and trying to stay in that property as long as they can. But every now and then we have borrowers that truly want to get out of their situation. They want to resolve their default. And we like those situations because we can think outside the box and we move a lot quicker than banks can. And we treat them as human beings. We really try and figure something out that's a win-win. So for a deed in lieu of foreclosure, it's critical that you run title checks. I was saying before that in a foreclosure, a lot of liens will get wiped away in the foreclosure. When you do a deed in lieu of foreclosure, they don't. So if there are any liens or defects on the title, they have to be dealt with, and preferably before the property transfer. You want to make sure that you're going to get no surprises, because once you do your cash for keys, which is kind of the final step in this process, the borrower is out. You have no more leverage at all, and if you're stuck with some tax bill that you didn't know about, that's gonna come from your bottom line. So have your attorney draft the documents. I don't recommend doing this yourself. I recommend having some airtight documents that will protect you. So some of these documents, contract for deed. Now, this is different than, like, typically when people talk contract for deed, it's kind of like a note obligation, but it's different. What I'm talking about specifically is a contract for deed for the deed in lieu of foreclosure, which just outlines what your agreement is. So your agreement typically will consist of two things other than that contract for deed. You get a special warranty deed, which is basically the borrower is deeding you the property, and there's special language in it that talks about what you're doing, and that basically it's satisfying your debt and all this kind of stuff. Typically, what we're trying to do is get that deed before the borrower vacates the property. And once we get that warranty deed, we want to record it as soon as possible, because once we record the deed, ownership is transferred. And then it becomes they're an occupant. And so it's a lot different situation than if they're still the borrower. So we want to change them from the borrower to the occupant as soon as we can. So the cash for keys agreement, that's a separate agreement that says, hey, I'll give you $10,000 or $5,000 or whatever the amount is that we agree. You agree to leave on this date, and you agree to leave the property in broom swept condition. Before we even enter into this contract for deed or deed in lieu, we'll have our agent go to the property and do an inspection and take pictures. That way we know what the inside of the property looks like. That way we can formulate what the appropriate amount for the cash for keys is going to be. So if the agent goes in there and sees that it's a disaster and that the interior is going to need a lot of work, well, that cash for keys amount is going to be lower. If it looks like they took care of the property, and that we're not going to have to do much to it, then there's a lot more money in the budget for us to give to the borrower, right? And it also gives us a metric so that when the agent comes back on the day that the person vacates, they can compare, hey, is the property in the same condition that we thought it was? Because if it isn't, then we're gonna have to redo this price. So it kind of keeps the borrower honest. And at this point, if they're cooperating with us, they want a positive resolution to their situation. They're probably not going to try and pull some fast one and leave a disaster for us. Generally, the cash for keys amount is not more than 1 to 2% of the property value. But again, it kind of depends. I mean, what is your business model? What did you buy the loan for? Because if you got a really good margin and you have a lot of profit in that deal, you might offer them more than 1 to 2%. It might be worth it to you to give that extra amount just to make sure that they're not going to fight you in foreclosure or change their mind and file bankruptcy on you. Get a signed W-9 from the occupant. If you don't know what that is, it's a form from the IRS. Basically, the person signs it and puts their social security number, or if it's a company, it would be an EIN. But you want to be able to, when tax time comes, you want to be able to report that cash for keys amount as income to that person. That way you get to write it off. And to be fair, I mean, a borrower who hasn't paid and is delinquent, and they're getting, maybe a windfall for them, they need to pay their taxes just like everybody else. The check is presented to them after the inspection on the move out date. So when you do the cash for keys, you give them the 30 days or 45 days or 60 days to move out. The agent, makes the arrangements to go inspect the property. It's in boom swept condition. Then they've moved all their stuff out. Boom, here's your check. And then at that point, it becomes an REO. So you just do exactly what we talked about in the REO strategy. But it's vacant at this point. So here's my third case study. For this one, this was a great learning example for me, because it was the first property or first note that we bought in a judicial foreclosure state. So I got to do everything. I got to start at the very beginning and initiate the lawsuit with the attorney, and we took it through judgment. So after judgment, there's a 90-day period in Illinois where they can redeem the property. If they don't if they don't pay the amount that's due, then it can go to sale. So servicing blues. So we use the loan servicer to service our notes. It's kind of like the equivalent of a property manager for a rental property, right? It's kind of a go-between. There are a lot of regulations involved in how you're supposed to treat a borrower. You don't have to use a servicer, but we do. We don't want to have the extra liability of not being in compliance with the latest regulations. And it's also it's a layer to keep between us and the borrower. So in this situation, though, we saw in the servicing comments that this borrower was trying to contact the servicer, trying to figure out a solution to their problem. And we watched for about a month as she was calling in. She couldn't get somebody to talk to her, or that person didn't know what to say, and she kept getting transferred. And we just got frustrated with it. We just said, you know what, we're going to call this lady directly and figure out what's going on. Because usually in my experience prior to that point, we never heard from the borrowers until the day of a sale, and they filed bankruptcy on us. So it was unusual for me to hear from somebody ahead of time. So we contacted her directly, and within a couple of days, we negotiated a deed in lieu. It turned out she was an older lady. Her kids had all moved out. She had this 2,000 square foot home that was too big for her. And she just wasn't making enough money to be able to make the payments. So she actually thanked me after this was all done, because it allowed her to get out of the huge debt on the property, which on this one really exceeded the value of the property. So she was stuck with it. There was no way that she could deal with it. And she ended up moving to Arizona to be closer to her kids in a situation that she could afford. So it actually worked out really well for her. So the final numbers on this one, we purchased it for $98,500. Total cost basis $129,882. We incurred some legal fees throughout the whole process. And once we took it back as an REO, we had to put some money into cleaning it out. This is I'm giving you the short story on this one. There was a lot more involved to this. It's an interesting one, but we don't have the time to go into too long of a story. We sold this one for and netted $147,000. Net profit was $17,000. Not the greatest return for us, but there's a variety of returns in the note business. I don't want to show you just all the great ones and show you that it's nothing but profit every way around. But when you do a volume of deals, you're going to have some deals that don't get you the best returns. So this one, we had it for over a year. The return on investment was 13.7%. Annualized was down to 10.9%. Any questions, Omar?
Yes, actually, Hamid asked a question here that you mentioned that if the property owner files for bankruptcy, the note holder is stuck with the note for 2 years? ?
Okay, so really quick. So if a borrower files bankruptcy, there's something called an automatic stay that that prevents any creditor from collecting on debt for that borrower. And that applies to everybody, right? And so there's a Chapter 7 bankruptcy, which is more of a liquidation, which that usually would only delay you by a few months because they're liquidating the whole estate. But if it's a Chapter 13 bankruptcy, it's a reorganization. It's a process that allows a person to reorganize their debts and give them more time. So they can come up with up to a 5-year plan where they're making the mortgage payment, they're paying on the arrears that's owed on the mortgage, and they're also paying on their other debts, right? But during the period of bankruptcy, you cannot foreclose. The only way that you can foreclose is if the borrower / debtor fails in their plan in some way, and you are able to go to the court and file a motion for relief, and the judge agrees. So the judge can take the property out of the bankruptcy, and that's what the 2 years I'm talking about. It's not exact. I'm just throwing 2 years out. It could be 5 years that you're delayed. It could be 1, it could be 3, depending on what happens, right? But you cannot foreclose on that property until the judge says that you can.
Thank you for that. That's very interesting. So it's like, so somebody filing bankruptcy, is that like the I guess like the worst thing you want to deal with in the note business, or one of those?
It's kind of one of the banes, right? It's we hate that.
Yeah.
It happens a lot. It happens a lot. Now I've gotten a lot of experience dealing with it. In my experience, it's maybe 1 out of 10 is legitimate. The other 9 out of 10, maybe 2 or 3, like legitimately think that they can do their plan, but they're not realistic about it. And then the rest of them are straight, just I'm going to try and delay this as long as I can. Yeah.
Okay, got it. And Kate just chimed in with a question here. Kate's asking, what's the average or approximate percent GE? I'm not sure, of good deals, 30% ROI versus bad deals, or percentage? Oh, okay. Oh, okay, got it. So what's the average approximate percentage of good deals versus bad deals? 30% or below 10%?
Well, that's kind of a complicated question to answer. It really depends on where you buy these things at. It's kind of like with regular real estate. It's your ability to buy right. If you pay too much, it's a bad deal, right? So we try to do as good a job as we can, but yeah, that would take us down a rabbit hole. And I'm looking at the time, Omar. I'm feeling the pressure a little bit. I want to get through the rest of it, and then
I guess it just comes down to your skills, right?
it does. Honestly, it does. I mean, and we're looking at tapes of loans to buy, but that's like, looking on the MLS or trying to find your off-market deals.
Right.
You can find an off-market deal that's not really a good deal if you don't price it right. So, but
yeah, I agree. Thank you, Kate. No need to be sorry about that.
Yeah. So short sale, short payoff. Again, so what you pay for the loan is different than what the borrower owes on it, right? So a short payoff is a situation where the lender accepts less than the total amount due on the note obligation. The borrower can use cash or refinance the loan. So the short payoff is just, hey, I'm the lender. On this note that you owe 200,000 for, I'll take 100,000 or I'll take 150, because they don't know that maybe I bought the loan for 50,000. They don't know, right? And if they're in a position to refinance, they can just refinance the loan. Or if they have some money somewhere else, they can just come give me that money and I'll be happy. Now, short sale, that means that a short payoff in which the exit is through the property. They don't have that extra money lying around. They can't refinance. The only way that they can come up with that money for the short payoff is to sell the property. Short payoffs are generally allowed when there's little or no equity in the property, because think about it, if they owe 100,000, properties with 200,000, there's no reason for a lender to take a short sale or a short payoff on it. I mean, they might if it's like, you know, I'll take 95 or I'll take 90,000 today, but if the property's worth 200,000, I know that if I foreclose, I'm going to get my full 100,000. So why should I discount it, right? Generally, we allow short sales when the borrower initiates contact. So this is particular for us. So if a borrower is trying to solve their problem and they've already contacted a real estate agent, they're trying to sell the property, they've already set up everything, then we're more inclined to accept it, because they're kind of handing us a plate and saying, hey, lender, I can't pay you the total amount that I owe, but I can't sell it for this amount, and I've already gone through the process and we just need your approval. If it's something where the borrower just generally wants to try and solve their situation and they suggest a short sale, we prefer doing the deed in lieu. We would rather say, hey, you know, we'll give you the 5 or 10 grand, you leave, and then we have a vacant house, right? We don't want to try and sell a house with you in it, because we don't know if you're, you know, if you're really going to go along with a plan, or if you're just going to, if you're going to cause problems. We can make more money off of it and have fewer headaches if you've already left. So that we prefer deed in lieu if we have to initiate contact, but if they already have the plan in place and they're doing it, we'll take a look at it. So the short sale payoff amount can be a flat amount or variable depending on how you set up the deal. So in general, like big banks and well, when they approve a short sale, they will just say, hey, you know, we might give you 5,000 cash for keys at the end of it, but we get everything else. We can be in a situation where we can say, well, you know, maybe we'll let the short sale amount be 150,000, and anything over 150,000 you can keep for yourself, like to provide an incentive for the borrower. Again, it depends on your business model and what you're trying to do and kind of your relationship with that borrower. As with deed in lieu, get the complete title work prior to entertaining the short sale offer. Liens don't get wiped out. They need to be handled prior to the completion of the transaction. So you got to have that knowledge when you're putting this deal together. And these are nice because you never have to touch the property. Kind of like with selling it at the trustee sale, and not taking the property back. Sometimes, you know, I'm doing my work from a desk. I'm sending emails and I'm making phone calls, but I'm never going to the property. So here's a case study. This is another one that we had just this earlier this year. So we bought this loan, and on the day that we closed on the loan, the seller told us, hey, the borrower contacted us, they want to do a short sale. So we immediately were able to start negotiation with them. The first thing we want to determine, is it a legit short sale or not? And what I mean by this is that some people, they say, hey, you know, my property is only worth $200,000, and, you know, will you do the short sale for $200,000? And you do some quick research and look up Zillow and Zome and Redfin, and you see that this property is worth $400,000 or $500,000 easy. That's not a legitimate short sale offer, and you got to be aware of that, because You have people try that all the time. So on this one we did determine that the offer was at market value. So it gives us some trust in the borrower in what they're trying to do. And so it makes it easier for us to work with them. If we get the borrower that's trying to snow us and say, hey, it's worth half of what it really is, we don't even bother with them. It's a waste of time. So on this one, there were back taxes owed of $120,000 to the IRS. If we can do a short sale with them, we can definitely foreclose and those liens go away. So we had to do the math. We had to look at what we were in it for, what this thing could reasonably sell for, what the liens were that this person owed that had to be taken care of, and do the math. And then we had to determine the right amount. So what amount was that? So a lot of these liens, like tax liens, they can be negotiated down. And actually in this situation, I was surprised at how far down they were able to negotiate it to. So they 120,000, they negotiated it down to 40 grand. So in a sense, we're giving up some of our potential profit that we can make by letting them pay these taxes off. But at the same time, we're able to ensure that we're going to get a return on our money as opposed to going all the way to foreclosure sale and having the risk that they file bankruptcy and then you're stuck in it for another 2 to 5 years. Much better to not be greedy and get a good return and then everybody wins a little bit. But in this one, we had a really great return. So it was 3 months from start to finish. Their first buyer fell through, but they found another one right away. Again, they went a long way towards building that trust with us and staying in communication. So it worked out. Purchase price of the loan, $260,000. Total cost basis, $261,000. So we really didn't have to put anything into this except our time and emails. We determined $360,000 was the right amount for that short payoff. So the net sales, again, we just had to pay some servicing fees. And that was it. Our net profit was $98,782. We held it for 80 days. That return, 37.8%, annualized through the roof, 172.6. Omar, I've got one more strategy to go through. And actually, I said 5 strategies, but there's actually a 6th one.
Yeah,
So I want to kind of motor through these, and then I'm willing to stay on for a little while to answer some questions too.
Yeah, go for it.
So the 5th exit strategy is resell the loan, right? So resell the loan to another known investor. You can do a straight flip. This is when you say you have the property that's worth $200,000, total debt on it's worth $100,000. You get that loan for $50,000. For you just work it out, right? Well, boom. Maybe you can find another investor who's going to pay you $70,000 for that loan. You could sell it, make 20 grand in like a month. I mean, maybe you want to do that. Value add. So if you think about real estate, anything that you can do to increase the value of that real estate will increase the value at which you can sell that property. Same for a loan. Say you buy a loan at 60 cents on the dollar as a non-performing note, you get it to reperform, the borrower starts paying again. Well, you can sell it for 85 cents on the dollar as a reperforming loan. So you've added value to it, and that's an exit strategy where you can make profit on that. If you've advanced the foreclosure, right? So that's adding value because you've spent money on attorney's fees and getting something from not in foreclosure to maybe, right up until it's about ready to go to foreclosure sale. That loan should sell for more than what you bought it for. Whoops. So these are reasons to sell those loans, right? So sometimes you need operating capital. All the loans in the portfolio are hard assets. You can sell them on the market and, you know, get some cash that way if you need money for an REO. Also, like some people think, you know, if they're in that loan for 5 years, maybe they want to sell that loan and redeploy it on better deals where they can make money quicker. So that's another reason. So here's a quick one. We had a sub-performing note with a borrower that was falling farther and farther behind. We contacted her directly. We found out that she owned a hair salon and that she was, you know, well, and actually, let me back up. So she reinstated and then she was reperforming for a while. And then we found out that she was doing consistent late payments. She was paying the middle of every month on the 15th. So the loan was due on the 1st and she was paying on the 15th of every month. We found out through talking with her that she owned a nail salon business, and she would focus on paying the rent for her salon first, and then she would make her mortgage payment second, because hey, and I have to respect that, because you know she's running her business, she needs to make money, and that's her main priority is to be able to make money, right? And then we were kind of in second place. But an easy thing solution we came up with is we just changed the due date. We changed the due date to the 15th of the month. That way her payments were on time. And when you want to sell a reperforming note, you want to show that you want to have consistent on-time payments. That's what adds value to a reperforming note. If we tried to sell this note with late payments every month, then the buyer of the note is going to ding us every time. They're going to say, hey, they're paying late on this note. You know, it's not worth as much as a note where they're paying on time. So just by changing the date when the payment was due, all of a sudden we had perfect pay history, right? She was paying on time. And so we were able to sell this note to a performing note buyer. And it was a win-win for everybody all around. Our numbers on this was a lower end asset, 25,000. Total cost basis. Now that number is actually lower than the purchase price. That's because we received income and we were receiving payments on it. So for our accounting and what we do, we intend to hold these things short term. We're not holding it long term. If we were holding it long term, then we would be reporting the income on a profit and loss, but we were reporting it on our balance sheet, approved by our CPA, by the way. So the net sales price, we were able to sell this thing for $48,765. And basically the sales price is dependent on yield, and the yield is dependent on what the loan payment is. So like I said before, the loan payment, the loan terms, all that stuff is independent of what we pay for it, right? So this loan is a contract. It says that me as the borrower, I'm going to pay X amount. This is how much I owe. The note buyer that's looking at this is looking at that payment, and they're figuring out a yield based on what they pay for it. And if that yield is acceptable to them, they'll pay it. So our net profit on this was 28,000 almost. We held on to this over a year because it was performing, subperforming, that kind of stuff. Return on investment was 134%, 150% annualized. Great. So this concludes my portion of the 5 exit strategies that I pursue, but I wanted to give you a bonus exit strategy. And this is one that I actually haven't done because this is not part of my business model and what we do. This is what the big banks are doing, and this is also what individual investors can do. Basically, it's strategy for people that don't have pressure on their money. I have pressure on my money because we raised it from accredited investors, and we structure it where they get a preferred return and a profit split. Well, that preferred return depends on time. So the longer that money, longer it takes us to get the money back to our investor, the higher the preferred return is. If you're a big bank and your cost of funds is 1 or 2%, or you have your own personal money and it's just your chunk of change to do what you want, this might be a better strategy for you. So basically, this means modify the loan in a way where the borrower can start making their payments again. Now, do you want to modify this to hold or to flip? So you can recapitalize the arrears. Basically, all the money that's owed on the loan, you can say, hey, you owe 100,000, like the principal balance, but you owe another 50,000 in back payments. What I'm going to do is I'm going to make it a new loan of 150,000 that's combined. And the reason you would do that is because that's what the unpaid principal balance, that is what most note buyers look to determine what they're going to pay for a note. They kind of look at like all the extra stuff is something that I might never get. So they will combine everything into one new loan, and that makes it a lot cleaner and easier to sell. You can extend the maturity date. You can start the 30-year amortization over. Yield considerations. If you are willing to accept a certain amount of yield, like say most investors in this category want a 9 to 12% yield, you can structure a new loan, make it due in 40 years, lower the payment, and get a yield that is acceptable to you. You can also do principal forgiveness, right? Oh, I misspelled forgiveness. But say on that note that is where the total debt is 200,000 and the property is worth 100,000. Well, you can say, hey, Mr. Borrower, I'll forgive $100,000 in principal and bring the balance of the loan to 100,000 if you start paying me again. Well, a borrower who wants to stay in their home might say, I'll take that deal. If you're in that loan for 50,000, it might make sense to you to do something like that. Make sure that if you do a loan modification that you comply with Dodd-Frank in the CFPB. And basically, the easiest ways to do that is to have your loan servicer draw up the loan modification documents, or you can have an attorney do it for you. That goes a long way with complying with the law and regulations. But as a general rule of thumb, just make sure that whatever loan you come up with, a loan modification, makes the loan better for the borrower. Don't take a loan modification where you're increasing their principal and interest payment by a couple $100 a month. It's got to be something where it makes it easier for the borrower, right? That's kind of like an inherent definition of what a loan modification is. You're modifying the loan to make it easier and better for the borrower, but you're also doing it in a win-win situation that increases the value of the loan or just makes it work for your business model. Best practices, you should record the loan modification agreement, and then you can resell the loan after 6 to 12 months of seasoning, or just hold it in your portfolio. So sorry to hit these last couple slides pretty quick, but I want to make sure I hit these timelines. We're exactly at 9 p.m. right now. Now to learn more, I'll just go through this real quick, Omar, and then give it right back to you if you don't mind.
No problem. Go ahead. Okay,
so I frequent a forum on biggerpockets.com that talks about notes. I'm always on it, and I'm always trying to add to the discussion and help people out with information, and sometimes get information for myself. You can also get information about me at my website, coastlinecapitalfm.com. I have a blog on there. I post articles, and then also news about my funds and that kind of stuff. And that's my email address right there, andy@coastlinecapgrp.com. And this information should be on the next slide as well. That's my business number right there. So that's my last slide, Omar. My website, email address, phone number. So if you want to contact me, you can contact me through that. And then I'll turn it over to you, Omar.
Well, we actually got another question that came in here. Hamid is asking, while holding the property, were you able to rent it out?
Yes, you can. You can. So if you're talking, if I understand you correctly, if you foreclose on our property and take it back as an REO, can you use it as a rental? And the answer is yes. So foreclosing on the home and taking it extinguishes the debt. So there's no longer a debt on the property, and basically you get the property to satisfy the debt. And now when the property is deeded to you, into your name, you can do whatever you want with the property. It's yours. It's in satisfaction of that debt. So if you want to hold on to it as a rental, you can. We don't do that for any of ours, but like I said, that's because of our business model.
Okay, great, fantastic. If anybody else has any other questions, go ahead and pop it in the chat. And it's the end of the night, so if you know how to unmute yourself, you can just go ahead and shout it out as well. Otherwise, I suggest going to Andy's link there on Bigger Pockets. Check out his blog there. I've read a few of his blogs. He's got some really great information in there. I'm gonna do one last Scott just sent out a thank you to you, Andy. You learned a lot. Excellent presentation, very helpful. Thank you for all the nice comments there. Give Andy some appreciation there. He really shared some great insider information there. I know I learned a lot. Very cool stuff there, Andy. All right, if we don't have any other questions, we're going to go ahead and conclude there. Another one there from a Greg. Well done. Well done, Andy, from Greg. And just
you guys are welcome, and thank you so much, Omar and Jeff, for having me on. I really appreciate the opportunity to speak to you guys. I hope you guys got some value out of it, and it was worth your time. Thank you.
Yeah, absolutely, Andy. Thank you for coming to our club here and sharing your knowledge with all our members here.